the participants. On behalf of Institute of Law, Nirma University, welcome Professor Michal Radvan from Czech Republic. Dr. Michal Radvan is Vice Dean for Foreign and External Affairs at the Faculty of Law, Masaryk University, Czech Republic, and he is also Associate Professor of Financial Law at the Department of Financial Law and Economics. He specializes in text law. He's the author of 5 books and the co-author of approximately 55 books. He presented his scientific research in more than 90 reviewed articles in prestigious journals and the conference proceeding. He's a member of the European Association of Text Law Professors and the Information and Organization Center for the Research on Public Finances and Tax Law in the countries of Central and Eastern Europe. Today, Professor Radvan will be giving his lecture on text drafting principles. So I welcome once again Professor Michal Radvan, and I also welcome all the participants. Just to brief, Professor, most of the participants are from the third year, and their third year of law. As far as the participants are concerned, I will just request all of you to just keep your videos on and try to be on mute mode. Okay. So, Professor, it's all yours.
Thanks so much. Good morning from the Czech Republic. Good afternoon to India. I'm really extremely happy that I was invited again for this magnificent party you are organizing in law. What is this legal month organized by Nirma University Institute of Law? I'm really very honored, and I want to talk about tax law. What is my area? It's very interesting area of law, not really popular among students, to be honest. But maybe you will like it. I will try to share the presentation. Of course, I expect a lot of questions from your side. Hopefully you can see the presentation. At least on my screen, it works well. So let me start. But I don't want to start with tax law. I want to start with my faculty, with my university, because for many people, as well from Europe, it's a mystery where Brno is, where Masaryk University is, and what does it mean. So you can see the map, and you can see where Brno is. Czech Republic is in the heart of Europe, and Brno is the second largest city in the country. It's also the center of Czech judiciary, what means that we have here the Constitutional Court, Supreme Court, Supreme Administrative Court, Ombudsman's Office, State Prosecutor's Office. So it's really perfect for us that we can cooperate with these institutions. Brno is also a student city. We have 13 education institutions here in a city with some 90,000 students. And Masaryk University is the largest one and the oldest one. It was founded in 1919. Maybe you know that the Czech Republic was created only in 1918. So during the first months of the existence of the country, Masaryk University was founded as the first really Czech university at the territory of Czechoslovakia. We have 10 faculties, and Faculty of Law is again the oldest one. We have some 3,000 students, 200 teachers, and according to THE ranking, we are at the moment on the position 88 of all law schools in the world. What is really something very beautiful, and we are proud of that. Okay, it's just a ranking, but maybe what is helpful in the ranking, we have really high number of English courses. We have more than 100 English courses every year. I would say that almost half of them are taught by visiting professors. And to be honest, I don't know any other law school where English is not the first language, with a higher number of English courses. And as we have the cooperation between NIRMA and Masaryk, I strongly believe that some of you are interested to join us and study with us in Brno. Now, text law, the not so interesting part of the presentation, I'm afraid. I want to talk about text law design and drafting, but for this, we must start in legal theory. And I have to tell you something about the method of text law regulation. We call it administrative legal method, well, modified a little compared to the classical one. Why? There is a really low level of applying substitutory regulations in text law. That's probably connected, or not probably, for certain, it's connected with the principle nullum tributum sine lege. And I will talk about this principle later on. As well, we are using a lot of economic instruments in text law to affect recipients. There are plenty of private law elements in taxation. I can mention postponing of taxes, payment calendars, options of lump sum tax, for example. Also, some certain administrative activities are delegated to private law entities. We can mention, for example, withholding taxes. When you are employed, so as an employee, your employer is doing a part of administration. He is responsible for cutting your advance payments, talking about, of course, personal income tax, so that you as an employee have no relation with the tax office. Everything is done by your employer. Also, the mandatory nature is moderated in certain instances with an element of choice. What is not very typical in public law. So, for example, you can apply for a lump sum personal income tax. You don't have any typical duties as a personal income taxpayer, but you just sign a contract with the tax office, and you pay at the beginning of tax year certain amount of money. In this amount, sometimes there is only tax, sometimes it's also connected with the social and health contributions. VAT, pretty new tax in India. And some people, depending on the money they get, are VAT payers, but you can become a voluntary VAT payer also. You can choose what methods of depreciation you are using. Sometimes you can decide whether you want to use lump sum expenditures or real expenditures when calculating the personal income tax base. Okay, these are the modifications, and probably we can find more, but what is the most important issue is something that is called self-application. It's not very typical in law. Very often, you have, and in public law, you have an office, and you go to the office and you ask the office for something, and they are in touch with you, they give you some advices, and they are helping. But in tax law, it's something impossible. You cannot go to the tax office and ask the lady there, how much? Here are my invoices, tell me how much shall I pay? No, you must be the tax law expert. As a businessman, as an employee, as a private person, as a company, you must be that expert. You must apply tax law norms on yourself, on your situation, so that you can set the tax base. You have to apply specific tax rate. You can apply, or sometimes you must apply the corrective elements necessary for your tax situation. You must know where is your tax office, when to file the tax return, when to pay, how to pay. So this is the self-application. And seriously, probably there is no other branch of law where this self-application is so strict. So that's why tax law drafting is so important, because people have to apply tax law norms on their self, on their situation, on their incomes, or any other taxable object. What are these results? The legislator simply should be receptive to the economic aspect of private life and business life. And the regulation should be not only perfect, but as well easy to understand and to apply. And I'm not talking only about taxpayers, I'm talking as well about tax administrators. So what are the tax law drafting principles? They play an important role in the process of tax law drafting and application. These principles consider both the public interest and the tax subject's individual interests or interests of other tax law addressees. And the legislator should respect basic legal principles given mostly by the Constitution. Then principles generally valid for legal culture. In case of Czech Republic, it's continental legal culture, and also the principles of the democratic rule of law. And let me talk about these basic principles. Mostly, we can find these principles in the constitutions, but not always. For example, Czech constitution is really very short, and there is almost nothing about taxation, about taxes, and about specific tax law principles. But what is there is the principle nullum tributum sine lege. This is the only principle, in fact, mentioned in Czech constitution. What does it mean? The state has the only chance to adopt taxes, a tax or taxes by law. It cannot be simply any bylaw or just the decision of the minister or of the prime minister. It must be adopted by the parliament. And very often we can see that, for example, municipalities or other local self-government units are adopting local taxes. This is of course possible, but again, in law, in acts, there is a permission for these municipalities to do that. And very often, the basic structural components of these taxes are regulated in law, in acts, and municipalities are only free to set details in their bylaw. So this is principle number one generally in the whole world. We have another very important principle of non-retroactivity. What does it mean? It means the prohibition of taxation of facts that occurred in the past, meaning the obligations arising during the effectiveness of a particular regulation is governed by this regulation until its fulfillment. And it might be broken, but only if the new regulation is better for the tax subjects. Tax subject will pay less according to the new regulation, even if these taxable events occurred in the past. The other very specific principle, not only for the Czech Republic, is international law. We have to follow international agreements, and moreover, in the Czech Republic, we have to respect EU law also. So, for example, all indirect taxes, talking about VAT, talking about excise taxes on petrol, on cigarettes, on spirits, on beer, on wine, on energy, these taxes are almost fully harmonized at the European level. Member states are only free to set specific tax rates. But again, in EU directives, there are minimum tax rates we have to follow. So we cannot simply say that the tax on petrol is zero, the tax on cigarettes is zero, because we have to follow these minimum tax rates. Other principles, in my opinion, tax provisions should be included in a separate legal act. This is, I would say, very common rule, and I would say it's followed by most of the parliaments in the world. But sometimes you can find one or two sentences about taxation in a specific act. For example, in the Czech Republic for decades, we have one exemption from property taxation, forest taxation, in the Act on Forests, and not in the Act on property taxes. So it was, again, very difficult for the taxpayer to find this regulation. And there were a lot of people, forest owners, who were paying this tax because they didn't know that there is an exemption hidden in another act than the Act on property tax. Also, what is important, it's necessary to follow uniform terminology in law. In tax law, we usually don't have specific terms or terms that are explained in a different way than in civil law or criminal law or administrative law. So we don't bring specific definitions, but we are following the definitions mentioned in these civil code, criminal code, or administrative law generally. What is inappropriate is to impose, I would say, special or unorthodox, or if I may say, stupid taxes or stupid tax components. This is happening also in Europe. For example, one of the most unorthodox tax in this country is a tax on dogs. We are taxing dogs, yes, not cats. In Estonia, they used to tax cows. In Germany, they are taxing horses. And I was asking in these states, experts living in these countries, why? What is the reason? They don't know. I don't know why we are taxing dogs, to be honest. They say it's a certain tradition. Not only here, it's collected also in Slovakia, Poland, Hungary, but I don't see any sense to tax dogs or cows or horses. In this presentation, I have two examples of unorthodox tax components. The one is an instrument called supergross wage. This supergross wage is my wage, 100% of my wage, increased by social and health contributions paid by the employer. What is at the moment almost 34% of my gross income. What does it mean? The supergross wage is in fact 134% of my income. And since 2008 until last year, that was my tax base. So compared to other, I would say, normal countries where the tax base is the income minus certain costs you have, what might be social and health contribution, what might be any other cost you have connected with your work. So normally people in other countries are paying the income tax from 70–80% of their gross income. But in the Czech Republic, we were using super gross wage. It means 134% of my income. That's why the tax rate could be only 15%. 15% sounds really good. If I start my speech at the conferences, so very often talking about income taxes, I start with the information that we are paying 15% only. So for many people, it looks like tax heaven. But if you mention that the tax base is the super gross wage, meaning 134%, usually the question is coming, Okay, how much is it in real? I can't tell you. I can't tell you because it depends on Indian regulation or Australian or US or French or whatever, because you have a lot of tax components hidden in the text, and the tax rate is just one of them. So you cannot simply compare tax rates to get the information how much you really pay, because you have to take also the tax base into account. You have to think about correction components and so on. The other very strange tax component we still have in our legislation is the tax bonus. Well, when I calculate the using the tax rate, the final personal income tax, I can use tax preferences for children as tax reduction. It's a fixed amount of money deductible from the tax. So this is again pretty normal situation. But what if the tax is pretty low and the tax preference for children is higher then you when doing this tax reduction, you can get below zero. In normal countries, you simply pay nothing on taxes. Your tax is zero. In the Czech Republic, this amount below zero is called tax bonus, and it's paid back to the taxpayer. Simply, the state is paying taxes to taxpayers and not taxpayers paying taxes to state. So this is really something very, very unique. Another principle, you should use understandable and unambiguous form. So there is no need to apply any of the contradictory principles called in dubio pro libertate or in dubio mitius or in dubio pro fisco. This is very often, these principles are very often used by the administrative courts, not only in the Czech Republic, but if you go to the scientific literature, for example, if you take Turoni's Tax Law Design and Drafting, I would say some kind of Bible for tax teachers, tax law experts. He states that really the legal regulation in the area of taxation must be so clear that judges have no chance to use these principles. And there are even countries where the constitutional courts decided that it's impossible to use these principles when interpreting the text. Also, tax duties should be formulated briefly and clearly. They should consider the level of legal and economic knowledge of the taxpayers. What is, again, very difficult. If you read VAT regulations, for example, this is really something that people with an average knowledge, legal knowledge, economic knowledge, cannot understand. But again, it starts at the European level. The regulation is pretty complicated. Then the translation into national languages, and then using the typical legal language in every country. And at the end of the day, it's really difficult to understand. Also, the title of the legislative instrument must clearly suggest that it concerns tax matters. And I have, again, a beautiful example from this country. Parliament adopted a tax on acquisition of immovable property. Well, reading the title, it looks that the person who is buying the property should pay some tax. But, well, and I have to add that this was the original proposal of the Ministry of Finance and of the government that was sent to the Parliament. But members of the Parliament decided to change the person of taxpayer, and they decided that it will be the seller. So still it was tax on acquisition of immovable property, where the object of taxation was the acquisition of immovable property, but the taxpayer was the seller. What happened in practice? A lot of sellers were not paying this tax, and when they were contacted by the tax office and asked to pay the tax, they said, okay, why? There is no such a tax. And they said, sorry, yes, a tax on acquisition is the tax you have to pay, even if you were the sellers and not the buyers. It was again changed some 6 or 7 years later, but it caused a lot of troubles, and this is the example how this shouldn't work and how this principle was broken. I have to mention as well a term, vacatio legis, meaning that we should have adequate time to be prepared for a new regulation. But what is happening, not only in the Czech Republic, Czech tax acts that should be effective from the beginning of the year are adopted by the parliament and published officially very late. And for example, for 2021, the new tax acts were published only the last day of 2020. So people don't have enough time to be prepared and remember that principle of self-application. The companies needed to prepare some technical instruments, softwares, and so on. So it's really pretty late for them to be ready. There are countries having a special principle mentioned in the constitution that tax acts must be published no later than 6 months prior to the beginning of that taxable period. But then think about the state budget, because state budget is very connected with taxes. If state budget is adopted by the parliament during the autumn, and of course it's effective in the next calendar year, you probably need to amend tax law also to be in line with this state budget. So when you have this rule and you have all tax incomes, in fact, ready 6 months prior the beginning of the taxable period, it's pretty problematic to prepare the budget, and the budget should follow as well the latest circumstances, especially in COVID times. I believe it was very critical for these parliaments, for these ministers of finance to prepare a really serious state budget if they already knew what will be, what the taxes will be and what the revenues will be. One more example from the Czech Republic. For example, there was a new regulation of communal waste charges prepared at the end of 2020, but it was published so late that municipalities didn't have enough time to prepare the bylaw for these communal waste charges. So what has happened? The parliament said, okay, we have a new waste act, we have new communal waste charges, but these charges will be collected by the municipalities in 2022 and later. And in 2021, you can use the existing, remember, not valid regulation. There are some more principles of tax justice, of course. We have a horizontal tax justice, a vertical tax justice, and of course you probably know what are the differences between these horizontal and vertical tax justice. We also have to follow the principle of proportionality, not to collect more than people are allowed to pay. And also I have to mention the principle of endurance, meaning the tax must not be of a liquidating nature, or the tax doesn't have a choking effect. What is generally secured by a lot of corrective components, what are exemptions, reliefs, and so and so. One very clean principle should be no double taxation. But we do have double taxation. We are fighting with double taxation internationally. We don't want people to pay taxes twice, once in India and for the second time in the Czech Republic if Czech person has incomes from the territory of India. But we have interstate double taxation. And again, we can talk about VAT and excise taxes, because the tax base for VAT is the price of the product increased by excise tax. So I pay VAT also from excise taxes. The example of super gross wage I have mentioned previously, it's again an example of double taxation, because according to OECD, for example, social contribution is a tax. So we were paying taxes from taxes. And also, it's necessary to protect the interests of the majority from the intrusion of different lobbyist interests. And where we have these interests of minorities, it's hidden usually in the corrective component. So you can take into account Indian tax system, and you can calculate how many corrective components you have in your Income Taxes Act. In the Czech one, there are some 400 corrective components. What are exemptions, tax reductions, tax reliefs, tax preferences for children, and so on and so on. I would say that 100 of them are really clever and necessary. I mean, if I sell my old cell phone because I want to buy a new one, I get certain amount of money, this is my income, but it wouldn't be fair to tax this income. So this is clever exemption, definitely. If I win a case with the state and state should me some compensation for damages, there shouldn't be any income tax again. But there are plenty of really strange corrective components, strange exemptions, and we should go through them, and we should probably think about these exemptions to be abolished. In US, they call it Christmas tree strategy, but in the Czech Republic, we have changed that a little, this Christmas tree strategy. So for example, now the Ministry of Finance is preparing a new Income Taxes Act, and they are using this Christmas tree strategy. They sent to the parliament just a tree, meaning the act almost without correction components. And they really expect that members of the parliament will add these decorations, these exemptions, reductions, and so on. People at the Ministry of Finance will prepare these decorations, meaning they will prepare the exact text of this exemption. They will be able to say where it should be placed in the act so that there is some systematic of the act, but they really expect that this will be the MPs who will hang these decorations on a Christmas tree. Because they know that if they prepare the exemptions in the draft, MPs will probably prepare another decorations, and that would be too much. Here is the principle of economic nature of tax law. Of course, the primal sense of taxation is the fiscal function and fiscal effort for public budgets. But also we have another functions, what might be the reduction function, stimulation function, and so on. So we have to think about the economic nature. And tax law drafters definitely must respect the economic rules of a chosen economic model. What means, for example, principles of an open market economy. They have to think about short-term and long-term consequences of the regulation. They have to follow regulation of related sections of public financial activities. They should see the impact of inflation for example, and so on. So, for example, my advice is not to use fixed tax rates or fixed corrective components because of inflation. At the moment, the inflation in the world is pretty high. In the Czech Republic, they say it's between 8 and 10%. So if you have fixed tax rates, you can see that the revenue of the state will be, of course, much lower. So at least if you are using fixed tax rates, it's clever to have some coefficient respecting the inflation. Almost the last issue is the professionality. In my opinion, proposals of the Act should be consulted with stakeholders. It should be discussed by professional committees. There must be really well done explanatory report to the Act. Well, there are sometimes troubles, sometimes it's misleading, sometimes, especially during the COVID-19 pandemics, most of the explanatory report was dealing with that COVID-19 pandemic, and it wasn't really connected with the real fiscal situation in the country. But if the Act is prepared by the ministry, is discussed at the level of the ministry for first. All departments have right to make some opinion. Later, there is a discussion with other ministries, with other commercial chambers, union chambers, universities, for example, so that the proposal is really very well discussed. In case of tax law, it's also the tax advisors chamber. Then it's discussed by the Legislative Council of the government. There is a special financial law commission. I'm the member of this commission. And then there is that we call big Legislative Council of the government. Until now, we have experts only. And they really understand very well these tax issues. But then what happens? It's adopted by the government. Very often the government believes in the opinion of these legislative councils, and then it's discussed in the parliament. And this is the issue. Members of the parliament, of course, have right to make amendments. But in this case, they don't prepare any explanatory report. Very often, these members of the parliament are not the experts. Well, at the moment, we are pretty lucky. I went through the list of members of the parliament, and in the first chamber, we have 4 people who were dealing with legislative before. In Senate, there is nobody. In the previous parliament, we had just 1 person who was, well, a bit experienced in legislation. Well, we should know that the legislation or the lawyers dealing with legislation are a bit different lawyers. They are not typical attorneys or judges, but they are trying to prepare the best acts than simply they could. So this is really a very specific profession, and we should use these people, and there is a lack of these people, of course, but we should use them and give them some vote. And when the Czechoslovakia was created in 1918, during the first years of the Republic, there were really perfect lawyers sitting in the Legislative Council of the government. And the members of the parliament were respecting these people, and they simply voted yes or no. They were afraid to prepare any amendments because they knew that the act was prepared perfectly. And if they disagreed, they said simply no, and they didn't prepare any amendments. So this is something what I was talking at the moment, that we have experts and non-experts. So after these non-experts in the parliament, we have again experts, legal advisors, tax advisors, judges. Again, these people are lawyers and they can understand the law and they can prepare the interpretation and application. So the only non-experts in the whole procedure are the members of the parliament. And here are some better practice examples, again, mostly from the Czech Republic. I have already mentioned the act amending the tax law acts for the tax law period of 2021 that was adopted really very late and published the last day of 2020. But what has happened here? The act was prepared by the Ministry of Finance and accepted by the government. But then during the procedures in the parliament, the Prime Minister came with the amendment. So he had a chance to do that when it was discussed at the government. He had a chance, of course, to call to Minister of Finance and to tell her, hey, I want to make some amendments now. No, he was waiting. And in the parliament, he brought, and according to his opinion, definitely a great idea, to abolish the super gross wage. Well, I completely agree. It's perfect idea not to have a super gross wage as a personal income tax base. But in COVID times, when the revenues of the public budgets are going rapidly down, and where at the moment where you have troubles to find adequate sources for public goods and services, it's not a good idea. Or it might be a good idea to cancel the super gross wage, but you then have to increase the tax rate from 15 to 20, 22, 25. I don't know, I'm not the economic expert. So, but definitely there are people who may tell you how much or how high the tax rate should be not to cut public revenues. But the Prime Minister didn't do anything. He just came with this idea to cancel super gross wage so that the tax base is now the gross wage only, but the tax rate remained at 15%. What does it mean? Especially rich people were paying less on taxes. And there was no compensation for state and for state revenues. Well, and because this Prime Minister was from the maybe populist party, we may say, and people from right wing always want lower taxes. All members of the parliament from right wing voted for. So really, the super gross wage as a income tax base was cancelled. And now we are in troubles because we don't have enough money in the state budget, and the state budget for 2022 wasn't still adopted until these days. Here are several conclusions. Tax law drafting principles are generally followed in all countries, also in the Czech Republic. They are clear, we know them, and they are easy to be applied, most of them. However, there are still cases that are showing us that these principles are not fully respected. And this is not because these principles are not clear enough or maybe difficult for implementation. But in my opinion, this is the role of politicians who are not fully following these principles, especially if they are seeking new voters. Thank you so much. And I hope you will have a lot of questions. Thank you.
Thank you, Professor Radvan, for enlightening our students on this very important topic of tax law drafting. You have discussed various important principles pertaining to tax law drafting. Here are a few questions from the participants. So first question is, which I may just take up. that it has been observed that European countries have been pioneer in introducing the environmental taxes. Can you highlight what considerations are significant and important which the policy makers need to keep while drafting such tax laws, particularly about environmental tax laws?
Thank you. Well, sometimes when you don't know the answer immediately, you may say it's a brilliant question. But in this case, this is a brilliant question. Well, environmental law is, the environmental rights are, I would say, very important, especially in EU those days. And you can see that in many constitutions where the right on healthy, favorable environment is adopted and secured, let's say. And of course, it has a lot to do with environmental taxes, because you may use taxes as we mentioned previously because of their reductive function. So you may reduce some negative behavior using taxes. And yes, very often people, especially those teaching environmental law, are telling us that energy taxes are environmental taxes, meaning taxes on energy, taxes on gas, taxes on fuels, for example. Sure, they have ecological aspects. I don't really believe that they are fully ecological, but they do have. In this country, I think we have more than 20 different ecological charges. So when you are polluting whatever into water, into the ground, you have to pay. Disposing with communal waste is chargeable. If you want to use agricultural land or forest for different purposes, you have to pay for this. So yes, ecological taxes and charges are very important, and you can see a lot of projects at the national, European level dealing with taxation and ecology. And I'm really fan of these charges, but remember always, do they really have that regulative function or not? And again, very often I see that some of these charges are having only fiscal effects and not that regulative effect.
Thank you, Professor. The next question is, what is the missing element, if any, that you would have come across the tax legislations across EU or any other legislations or from any other jurisdiction, if plugged, could go longer way in reducing the tax litigation? So the participant is asking regarding if any missing element that you have come across in the tax legislations, if plugged, could go in longer way in reducing that tax litigation. Because in India particularly, we see probably that was a reference, a lot of tax litigation. So I'm sure that it is it is same might be in the EU. So any missing element if you have come across?
Well, to be honest, I'm not the expert on international taxation. And concerning the number of litigations in this country, it's close to zero, maybe if it's even zero. So it's not very, very common here. There is a pretty new regulation at the European level. And according to this regulation, it will be possible to have litigations between states to decide where the taxable income should be really taxed. But I'm afraid it wasn't still implemented in many countries, including the Czech Republic. So this is what we are missing, the real implementation of EU directives into the national law.
Thank you, Professor. The next question is pertaining to a reference has been made in the your presentation. The participant is asking, can you elaborate upon when you say that tax should not be of liquidating nature under the principle of endurance?
Well, again, it depends on personal situation of each taxpayer. I would use one example. It was the example of property transfer tax that was collected in this country for decades. It was 2008, 2009, I'm really not very sure, when this case was discussed at the Supreme Administrative Court. And the Senate of this court, 3 members of the Senate, voted, and they decided to ask the Constitutional Court whether this tax is constitutional or not. And they were arguing with this choking effect of the tax. It was, those days, it was between 3 and 5%. The rates were changing, so I'm not really sure what was the exact rate those days, but between 3 and 5% of the market value or the price in the contract. And the Constitutional Court stated that this is not the case of choking effect, so that people still have enough money to pay. I don't know what would be that rate that would be really too high for the Constitutional Court. But if you go through Europe, especially if you go to Scandinavian countries, you can see that the highest personal income taxes are more than 60%. I am afraid that for the Czech Constitutional Court, this would be too much. And one more issue from France. During the economic crisis in 2010, 2011, the most rich persons from France, led by Esther Lauder, the owner of that Lauder empire, she came with an idea to be taxed by 80% for a short moment, for 2-3 years only. She and her group was ready to pay more, 80% on property, on income taxes. And this is something that would probably never happen in the Czech Republic. This would never happen in Southern European countries or Eastern European, because this is too much for us. But as well, people in France, not all people in France were ready to pay 80%. So we could see that Gérard Depardieu, the famous actor, has moved to Dagestan and later to Belgium, because it probably wasn't very comfortable to live in Dagestan. But now he's, as far as I know, the resident of Belgium, because in Belgium the highest tax rate is lower than France. Maybe he should move to the Czech Republic, because the highest tax rate here is 23%, or maybe Bulgaria, where it's 10 only.
Thank you, Professor. The next question, if I may take it, there was a proposal in your presentation that there should not be a fixed tax looking at the inflation. Don't you think that can bring in the uncertainty, especially for the new investments?
Yes, sure. But the thing is, where we are using fixed tax rates. Mostly it's tax on motor vehicles in this country. It's a property tax, and maybe the dog charge I have mentioned. We are not using many fixed tax rates. If we have any inflation coefficient, this would be helpful. And I'm really not afraid that we would lose some foreign investors. Maybe we are using the foreign investors if the corrective elements, corrective components are fixed. So if I have, for example, the basic tax relief just because I exist, this is the rule, especially for poor people, not to pay taxes. So we have almost linear tax rate, but still progressive taxation. But this number is still the same. But because of inflation, it should be higher. So yeah, we should have any inflation coefficient, and we have to define what is influenced by this coefficient, just rates or also other corrective components. And of course, then you may attract additional foreign investors.
Thank you, Professor. So we have come to the end of this session on text drafting principles. So I take this opportunity on behalf of Institute of Law, Nirma University, to thank Professor Michal Radvan for highlighting certain important principles of drafting principles of text laws. I thank Director ILNU, Institute of Law, Nirma University, faculty colleagues, support staff, especially Mr. Digan Rathore, in enabling the smooth conduct of this session. I should not forget all the participants, our students. So I thank all the participants for actively participating and just coming up with such good questions. I'm sure the lecture of Professor Radvan would have given enough enlightenment to the student to further analyze the drafting principles of text laws. So thank you all. Thank you.
Thank you so much. Have a nice day, and I hope to join you next year again.
Sure, Professor. Sure.
Thank you. Have a nice day. Bye-bye.
Have a good day.